Hey everybody, Paul Vojchehoske here, and I'm going to continue my series on the legislative bills before the Nebraska legislature revolving around landlord-tenant issues. And the next legislative bill I want to discuss is 846. This was introduced by State Senator Megan Hunt, and it deals with bed bug detections. Now, this is kind of a lengthy proposed statute. It's about 8 or 9 pages. I've kind of broken it down to the top 8 major themes within that proposed statute. There's a lot of minor details in there that I'm not going to cover. If you want to read the proposed statute yourself, I'm going to leave a link to the PDF to this proposed statute down in the video description. So as I said, there are 8 points I want to bring to your attention. The first one is it would require the tenant to notify the landlord or manager of a possible bed bug infestation. So that's where it all starts. The second thing that happens is within 96 hours of receiving that notification from the tenant of that possible bed bug infestation, then the landlord has some things that they have to do. The first one is they have to engage a qualified inspector. And I'm going to talk about that at the end of the video, what a qualified inspector is. They have to engage a qualified inspector to perform an inspection within 96 hours of notification. It's not business hours, it just says 96 hours. Number 2, if the inspection confirms that there are bed bug issues, then the landlord shall, meaning they have to, have the contiguous units inspected. So what does that mean? So initially within that 96 hours, the landlord would have to have the individual units inspected. If it's positive, then they would have to have the units co-located next to that subject unit to be inspected as well. Number 3, the landlord has 2 business days. They have 2 business days to notify the tenants of the inspection results, whether they were positive or negative. And then number 4 is if the inspection is negative, and this is compulsory on the landlord. So if the inspection is negative, the landlord has to inform the tenant that if they have any concerns that are remaining, then they have a right to contact the local health department. The rules and regulations that will be developed around here, I'm sure will say that has to be a written notice from the landlord. We'll see how that plays out if this passes. But any negative inspection would still require the landlord to inform the tenant. They can call the health department if they still have concerns. All right, bullet point number 3, the landlord shall within 5 business days of the inspection start the treatment process. And for anyone who's ever been through the treatment process for bed bugs, they know that it starts with preparation even before you get to the treatment, but they have to start the process within 5 business days. Bullet point number 4, the landlord's responsibility to pay for all the treatment and inspections. That's not something under the statute that's allowed to be passed on to the tenant, at least under the current form that this statute is written. All right, number 5, the tenant can be held liable for the costs if the landlord can prove that the tenants, basically if the tenant doesn't comply with the treatment plan that was given to them by that qualified inspector, then there is a venue or an avenue where the landlord could go after the tenant for costs. Yeah, good luck with that. But it's only reserved and restricted to if that tenant failed to comply with, and it was knowingly or willfully failed to not comply with the treatment plan that was put forward by the qualified inspector. There's nothing in this proposed statute that says that if you can prove that the tenant brought the bed bugs in, that they pay for them. There isn't anything like that in this proposed statute. The cost is completely borne by the landlord, with this one exception. Bullet point number 6, there's no requirement for the landlord to provide the tenant any kind of alternative housing or pay for their personal property that has to be thrown out. There's no requirement. Okay, bullet point number 7. If the tenant requests this information And this is a trigger provision, meaning that they have to request it. So that it's not, the landlord doesn't have to provide this information. They only have to provide it if it's requested by a prospective tenant. But if that prospective tenant asks for the information, then the landlord has to provide whether the dwelling being offered for rent contained any bed bugs within the previous 8 months. I don't know how they came up with 8 months, but that's what the proposed statute says. And one additional piece of information, if the tenant requests, then you must provide the date that the dwelling was inspected last and found to be free of bed bugs. So those are 2 things that you would have to do. Again, these are trigger provisions. That means the tenant has to make the request. Bullet point number 8. A landlord who fails to comply with this statutory requirement is liable to the tenant for actual damages. So this is going to be one where you're going to have to come up with a process for these type of issues that comply with the statutory and the regulatory requirements. Because what's going to happen is the Department of Agriculture is going to get this if it passes, and then they're going to write rules and regulations around the statute that's going to be that you're going to have to comply with. All right, so 2 things in addition I want to opine on. Number 1 is this statute gives, and I'm sure the follow-up regulations that will be written by the Department of Agriculture, they're going to give that qualified inspector a lot of latitude. Now, a qualified inspector under the statute is defined as a licensed certified applicator or a commercial applicator who is retained by the landlord. So this means that your maintenance person or the landlord themselves is not going to be able to do it unless they are a certified applicator, a licensed certified applicator. And even then, I don't know that the law, the way that it's written, would even allow that, because it does say they are someone who is retained by the landlord. So that's going to be the legal argument. Meaning that there was nothing in the statute that allowed for the landlord, who may be a licensed applicator, to be able to fulfill that duty. I don't know. That will be something the courts will have to decide. And one other thing I want to add on to that is the inspection company is in full charge of the process. So if, let's say within 96 hours that tenant notifies you and you get a qualified inspector out there, and the inspector, they inspect the unit and something's like, if they want to see additional units, then they're going to have a right to do that. And you know who's going to have to pay for that? That's going to be you. So understand that the inspection companies are going to have a lot of latitude kind of in controlling this situation, because they're going to be the ones that are going to put their John Hancock onto an inspection that says that it either has or it is free of bed bugs. And so that's something that you're going to want to prepare for if this particular legislative bill passes. All right, don't forget, there's going to be a link to the PDF down below in the video description so you can read this for yourself. And I do think you probably should, because I think this actually has a fair shot, based on the information I'm receiving, to actually pass. All right, if you want to continue researching other legislative bills that I've discussed, I'll leave a link right up here somewhere. See y'all in the next video.